On the Keller at Large MASSter List podcast, Jon Keller recently shared his personal hot take on the Desrosiers versus Baker case that I argued before the Supreme Judicial Court on September 11th. Quoting a character from Charles Dickens' Oliver Twist, who famously declared, "The law is an ass," Mr. Keller said, quote, "Sometimes that applies to lawyers too," unquote. Well, two things are certain. First, the Constitution is not an ass. It is the supreme law, the bulwark protecting our civil liberties from arbitrary rule. Second, Desrosiers versus Baker is no joke or nuisance suit. Rather, it raises fundamental questions about which brand of government may exert police power over citizens. Fear of the COVID-19 crisis is understandable, but fear of a crisis is never a reason to abandon the Constitution. Indeed, the principal purpose of a Constitution is to protect society from momentary passions and prejudices that threaten our civil liberties, especially in times of crisis. In other words, we need the Constitution now more than ever. The Constitution's separation of powers protects civil liberties by dividing authority among three branches. It's the legislature's exclusive duty to pass laws to protect the public. The legislature alone exerts the police power. Massachusetts' highest court has explained that the police power includes the right to legislate in the interest of public health, safety, and morals. So the legislature has chosen to protect the public from invasions and catastrophic storms in the Civil Defense Act, and from pandemics and diseases in the Public Health Act. These are two distinct laws that protect the public from distinct threats. The governor's duty is to execute these laws, not to rewrite them. The COVID-19 health crisis does not empower him to ignore the Public Health Act or to reshape legislative health policy to his liking. Yet that's exactly what Governor Baker has done by declaring a health emergency to be a civil defense emergency. Governor Baker may disagree with the legislature's policy choices, but the Constitution doesn't permit him to make law by executive decree. His executive orders violate the separation of powers, and yes, recall the brand of monarchical government Massachusetts cast off in 1775. John Adams crafted Massachusetts' separation of powers to secure, in his words, a government of laws and not of men. The paramount significance of Adams' principle is clear. The government's police powers severely impact the personal liberty and livelihood of citizens. So only the legislature, the body closest to and most responsive to the people, can be trusted with such awesome and terrible power. Only the legislature, through the normal lawmaking process, can impose a kind of suffering that Governor Baker's executive orders have caused. And only the legislature may suspend laws, and even it can apply the law to some people and not to others, the way Governor Baker has done. Desrosiers versus Baker asked the Supreme Judicial Court to return Massachusetts government to one of laws written by the legislature, not of orders decreed by one man, however well-intentioned he may be. NCLA's lawsuit is not a joke. It poses serious questions of constitutional governance, and it promises to restore the Massachusetts body politic to its pre-COVID-19 health and vitality.